Hello, everyone. Thank you for joining us today. We're going to give a little seminar today about reasonable accommodations under the Fair Housing Act. And my name is Cliff Davis. I'm a shareholder here with Roberts, Markel, Weinberg, Butler, Haley. And I'm being joined by Ashley Koirtyohann today. She's really the expert in this. She knows a little bit more about it than I do. But we're going to kind of go over the 30,000-foot view of reasonable accommodations, which a lot of you may have experience, with things like group homes or somebody who wants some type of improvement that would otherwise probably be something that you deny. So the kind of topics we're going to cover today are the Fair Housing Act, and what are reasonable accommodations and reasonable modifications, common types of requests, qualifications for reasonable accommodations or modifications, and talk about some potential issues. So the Fair Housing Act is really, it's a federal law that applies. That's primarily what we're going to be talking about. And it applies to most housing related activities. And that includes the enforcement of rules and restrictions. So enforcement of deed restrictions by a property owners association. And the Fair Housing Act said it is illegal to discriminate against an individual on the basis of color, race, national origin, religion, sex, familial status, or disability. And the law states that housing providers must make reasonable accommodations that may be necessary to allow persons with disabilities to enjoy their housing. And the Fair Housing Act can be found, it's part of the Title VII of the Civil Rights Act of 1968. And a lot of the interpretation and guidance for this law comes from the Department of Housing and Urban Development and the Department of Justice. And the Department of Justice has the enforcement authority for this act, along with some state agencies too. And that's something you got to be careful about, because, and it has happened before, where if somebody violates this act as a federal law, the Department of Justice can send attorneys down to prosecute that violation. And obviously you never want to be on the other side of that type of an enforcement action. So let's talk a little bit about what is a reasonable accommodation. And the law defines that as a change, exception, or adjustment to a rule, policy, practice, or services that may be necessary for a person with a disability to have an equal opportunity to use and enjoy a dwelling, including public and common use spaces. So it's this law, as you can kind of tell from some of these definitions, is very broad, protects a lot of things that a person that's a protected class under the law requests, and you have to really be careful. This may include things like a parking accommodation. If you've got a person who is handicapped that needs a parking space that would otherwise be a visitor parking space closer to their unit, and they ask for an accommodation, it's probably something you're going to have to do. Or for another example would be if someone has a house and they're in a wheelchair and they need a ramp to get into the front entryway of their house, which might be the type of a structure you would otherwise deny. They can request an accommodation under the Fair Housing Act, and you are probably going to have to give them that accommodation and allow that to happen. So a reasonable modification is another thing that people can ask for. It's a structural change made to existing premises, occupied or to be occupied by a person with a disability, in order to afford such person full enjoyment of the premises. And if someone does ask for a modification, that party is responsible for paying the cost for it. So you don't really incur the cost of the person's request and granting the request. It's the requesting party has to pay those costs. So the enforcement part of the law is that the Fair Housing Act makes it unlawful to refuse to make a reasonable accommodation or allow a reasonable modification when such accommodation or modification may be necessary to afford persons with disabilities an equal opportunity to use and enjoy a dwelling. And you keep seeing those same kind of words. It's if this is going to allow someone with a disability an equal opportunity to use and enjoy their residence, it's going to fall under the protection of this law. So some of the common requests you may see may be assistance animals, emotional support animals, a driveway extension. I've dealt with numerous requests where an owner is handicapped and is in a wheelchair or something, and they ask if they can extend their driveway over 3 or 4 feet to allow to get in and out of their vehicle. And that's going to constitute a request for a reasonable accommodation. And then there's no magic words, and I think we'll talk about that some more later. But those are the types of things that you'll have to allow. Wheelchair ramps that we talked about, exemptions from certain types of architectural rules. You may have to give an accommodation on an architectural rule that would otherwise make it more difficult for this person to enjoy their house. So the qualifications would be if a person is generally entitled to a requested reasonable accommodation if that person meets the Act's definition of a person with a disability, and there's a nexus or a connection between that disability and the requested accommodation or modification. So that you've got to look at these requests very carefully. You've got to be careful about how you respond. You've got to be careful about if you see something happening, and probably one of the biggest examples of fair housing issues comes with group homes, where we'll get contacted by a board or a property manager, and they'll say, hey, we've got a house over here and there's like 7 people living in it. And that's a violation because it's more than a single family, or they're operating a business. There might be a caretaker that lives there. And so they're operating a business out of this house. Well, if those people are disabled, that's going to be the kind of thing that's protected by federal and state law. And the protection comes under this Fair Housing Act. So you've got to be careful when you see that about how you respond. If the persons if the persons living in the house are clearly disabled, you can tell by sight, and you send them a violation letter, that has been found to be an act of discrimination. So you've got to be careful about what you see, and sometimes you can see the disabilities and sometimes you can't. But when you're faced with these situations, you got to be careful about how you proceed. You should probably get your attorney involved. You can ask for some information if you're not sure what's going on, but you have to be very careful about how you ask for it. So let's talk about a little bit about how the Act defines a person that has a disability. And again, like I said before, this law is very broad, and you can see from the definition that it's very broad. It's individuals with a physical or mental impairment that substantially limits one or more major life activities. So, that can be walking, working, just almost anything that a person without a disability can do without an issue. If that ability in a person is limited, they probably qualify as a disabled person under the Fair Housing Act. It's individuals who are regarding as having such an impairment, individuals with a record of such impairment. If a person's disability is not obvious or readily apparent, like I said, you can request some documentation. You've got to be extremely careful about how you request it, the words that you use. So those are the types of things that really, the purpose of this today is to make you aware of this law, if you're not already, to make you aware that it's a very broad law, and to really kind of make you aware that if you're faced with a situation where you think this may be applicable, to be careful about how you proceed. I'm going to let Ashley jump in here, and she's going to talk some more about requests for accommodations.
Thanks, Cliff. So one important thing to note is that there's no requirement that a request be submitted in any particular fashion. So however it comes to you, you do have an obligation to consider that request. So for example, an association can adopt a policy that maybe creates a form and says to owners, you can request a reasonable accommodation or modification by using the form attached to this policy. But even if you have something like that in place, if an owner comes up to you during a board meeting or even just on the road and says, hey, I'm disabled and I need this accommodation, or I need, can you waive this rule for me or something like that, then you still have to consider that, whether or not it's submitted in compliance with any sort of policy you might have. And it doesn't have to be submitted by the disabled individual. It can be submitted on their behalf. We see that a lot in the context of parents submitting a request on behalf of a child, or even a caretaker or social worker or family member submitting on behalf of an adult, maybe who has cognitive disabilities or some other issue that makes it difficult for them to make a request on their own behalf. The request doesn't have to use the phrase reasonable accommodation or modification if it's clear that the person is requesting some sort of variance from a rule or some sort of architectural change based on something that may qualify as a disability. The association should treat that as a request, and if necessary, request additional information or whatever you need to be able to fully assess that request. But you can't really bury your head in the sand and say, well, we didn't know that's what they were asking for because they never said the words reasonable accommodation. As far as what situations allow an association to deny a reasonable accommodation request, if it doesn't meet the qualifications that Cliff discussed. So if the request was not made by or on behalf of a person with a disability, then that person's not entitled to a reasonable accommodation under the Fair Housing Act. That is something that you want to be careful about. So if somebody has submitted, say, a doctor's note that says this person has a disability, it's really not the board's position or a manager's position to second guess that, even if you think, oh, well, they probably just went out and found a doctor to write something, which a lot of people do, but the Fair Housing Act and the related guidance doesn't really give housing providers, which can include POAs, the opportunity to challenge documentation that otherwise complies. If there's no disability related need for the requested accommodation or modification, you can deny it. An example of this would be, and this is one that's used by the Department of Justice in some of their guidance materials. If there is an owner with a mobility impairment who does have a disability, but they request to use a different type of shingles than what is required on their roof, and the justification they give is that they like the way it looks better. There's no connection between the owner's disability and what they're requesting. So that could be denied. There is some language in applicable guidance that would allow a housing provider to deny a request if granting the request would pose an undue financial or administrative burden to the housing provider or fundamentally alter its operations. It's very unlikely to come up in the context of POAs, since most accommodations take the form of just like a variance from a rule or choosing not to enforce a rule. This is more applicable to, say, like an apartment complex. And the example we'll given in the guidance is if a tenant requests that an apartment complex provide him transportation to and from the grocery store, and the apartment complex doesn't provide any sort of transportation, that's a fundamental alteration of their operations and also an additional financial and administrative burden. So that sort of request could be denied, but it's a very narrow request, or a very narrow exception. So to the extent you think that might apply to a request that you are processing, I would recommend consulting with your counsel. In the housing requests that I've handled, I've never seen one where that last bullet point would apply. So next we're going to discuss about some of the potential issues, which I think are really important to keep in mind when you're evaluating these requests. And Cliff touched on this earlier. If somebody files a fair housing complaint, it could be handled by a number of agencies, all of which I or other attorneys in our firm have had experience with. So when we advise our clients, it's not just the Fair Housing Act and the guidance, but also the past experiences we've had with the ultimate decision makers on a fair housing complaint. So in the Houston area, it's typically the Texas Workforce Commission Civil Rights Division. There are also city level agencies that might do it. So in San Antonio, there's a Fair Housing Council of Greater San Antonio. So there are different agencies, but they are really advocates for disabled individuals. And I think a lot of times the thought process is that they would rather, if some people are going to get through the cracks taking advantage of the law in order for people who do genuinely need accommodations to get their accommodations, they seem to be kind of okay with that. So a lot of times there might be a situation where an association has a legitimate reason to doubt the validity of a request, but like our ultimate advice is very often going to be to grant it, because you're going to find yourself up against one of these agencies. And we've worked on complaints where that agency has come back and told an association, we're going to issue a finding of a discriminatory housing practice if you don't grant this accommodation. So these are the potential issues that can arise if you grant an accommodation and find yourself up against either a complaint or a lawsuit. So before you make the decision to deny a request, you should consult with counsel. You should provide the requesting party with a decision in a timely manner, whether that's to grant or deny it. And that's because an unreasonable delay in issuing a decision can be considered a denial. And you have to review every request on a case-by-case basis. So you can't have just like a blanket response to every type of request. So, one owner might request an accommodation that you have a reason to deny, but the same type of request might come from an owner where the circumstances are different and it needs to be granted. There's I won't say no liability risk for granting an accommodation, because there could always be somebody like a neighbor or somebody who complains about it, but the risk associated with granting an accommodation is minuscule compared to the risk that's associated with denying one. If the request is denied, the guidance suggests that POAs should do something what's called engaging in the interactive process with the homeowner or the tenant. So that can be rather than just sending a letter, your request has been denied. There should be some sort of ongoing discussion, explaining why the request was denied, and perhaps discussing potential alternative accommodations or modifications. I will say that there is guidance that suggests that if there are two potential accommodations, that the homeowner is the one who gets to decide which one to go with, because they're in a better position to understand their disability and their needs. So the guidance leans very heavily in favor of owners. So it is something to keep in mind, but in the event that a complaint is filed or a lawsuit is filed, it's always helpful to be able to show that the association tried to work with the owner and didn't just, deny a request and then shut them out. The potential liability can depend on a number of things. The Fair Housing Act grants complainants the opportunity to file an administrative complaint with one of the agencies that I was discussing a moment ago. There are laws that require a complainant to exhaust their administrative remedies before they can file a lawsuit, but the Fair Housing Act is not one of those. So most people will choose to file a complaint. They have 1 year to do so. Most people choose that route because it's free and the form is fairly simple, and you don't typically need an attorney to assist you with filing a complaint. So a lot of people will go that route. Alternatively, they can jump straight to filing a lawsuit. That's more expensive, difficult to do without the assistance of attorney, but some people do choose to go that direction. You have 2 years to file a lawsuit. That 2-year period is tolled or paused if they choose to file a complaint. So the 2-year period won't run in that case, and won't begin to run in that case until the fair housing complaint has either been resolved or dismissed. In terms of potential damages, this will depend again on, so if a complaint is filed, the agency isn't going to issue penalties. Basically, they either say, we think a discriminatory housing practice occurred, or we don't, or we didn't have enough information to make a decision. And then if it was found that a discriminatory housing practice did occur, either the Department of Justice or a local agency may choose to file suit to pursue that. So this assumes that either the homeowner or one of these agencies has filed a lawsuit. If it's filed in civil court, the potential damages include actual damages, punitive damages, and attorney's fees. And punitive damages can get pretty substantial. Attorney's fees can get pretty substantial as well. You also have the opportunity as a homeowner to have an administrative law judge or an ALJ hear your complaint. In an ALJ hearing, ALJs cannot award punitive damages, but they can award civil damages. So in that case, you're looking at actual damages, civil penalties, and attorney's fees. And the next slide is going to go over what the current civil penalties are. This is adjusted every year for inflation. So I believe these are actually 2021 numbers that will likely be adjusted up sometime around March. If for your first violation, $16,000 is the maximum. If you have a previous violation that's occurred within the last 5 years, that jumps to $37,500. And if you have 2 or more previous violations within the past 7 years, the maximum is $65,000. That's a lot of money, but it is probably less than might be awarded in punitive damages in a civil lawsuit. So that's just something to keep in mind. Another potential effect is the effect that violation of a civil rights law can have on volunteer immunity. The Federal Volunteer Immunity Act shields individual volunteers, which in our case is usually board members, from liability to the extent that they were acting in good faith and acting within the scope of their volunteer duties. And that is a very broad summary of volunteer immunity. We do have, I believe, a blog post and a webinar from around this time last year that you can find online that goes into like much greater depth on volunteer immunity and the standard of care. But that's a very generalized statement about how it works. But there is an exemption in this Volunteer Immunity Act that says you lose that volunteer immunity if the allegation is misconduct for which you're found to have violated a federal or state civil rights law. And as Cliff mentioned at the outset of this webinar, the Fair Housing Act is a subset of the Civil Rights Act. So this would fall under that. So you do want to be careful because it's possible that not only the association, but also individual board members could have liability for violation of a fair housing law. I imagine in that case, they would look at things like whether the violation was intentional or just a misunderstanding of the law. And there are a lot of steps before you find yourself reaching an ultimate decision on liability. You have the opportunity to engage in mediation and things like that. But that is something to keep in mind. It just sort of a generalized conclusion on how to handle these requests. It is a good idea for associations to engage in regular fair housing training once a year, once every 2 years. That might be offered by a law firm. I believe there are also civil rights divisions of certain cities that will come out and provide fair housing training. So that is something to look into. And that's just so you can recognize these requests when they come in and have a better understanding of when you might need somebody to come in and assist you. We always recommend consulting with legal counsel regarding a request because a lot of fair housing law is not intuitive. And a lot of our recommendations, at least, are based on significant experience we have with the agencies that interpret and enforce these laws. If an association receives a request, it should be considered in a timely manner. It should be considered carefully. The association should be careful about the type of documentation it requests. And just as a sort of side note, associations should consult with either their counsel or their insurance brokers to determine if responding to an administrative complaint is covered by their D&O insurance policies. I have not seen a policy where that's not the case, but it is possible. So I would just check with that because responding to a fair housing complaint, while significantly less expensive than a lawsuit, does take some time and some money. So I think that's it. We had some questions that were pre-submitted. Should we go through those first?
Yeah, we can go through those.
Okay.
I'll start it. We had some pre-submitted questions, and we've had some people type some questions in the Q&A. If you have a question, you can type it into the Q&A function of Zoom, and we will try to get to all of those also. The first question is designating a handicap parking space from standard guest parking for an owner who requires it. Does this affect the number of required parking for the community? Do we have to offset the designation with another standard parking space within the community? I mean, I think the answer to that is no. If you've got, if a person that's protected under the law is disabled and requests an accommodation, that they be able to use what would otherwise be a guest parking spot. And, as long as you've got the sufficient documentation that it is related to their handicap, you can designate that parking space as for that person to use. And you don't necessarily have to go find another parking spot somewhere and make it a guest parking spot. Ashley, you want to take the next one?
Sure. We had a question about a community where the city requires the association to handle front lawn care. And to the extent that somebody requests or says, we don't want these chemicals applied for health reasons, is that treated as a fair housing request? And do we have to grant it? That alone is probably, I think would trigger follow-up questions. They haven't claimed to have a disability. They haven't really given any information. You might request the sort of information you're allowed to request under the Fair Housing Act, which is basically documentation from a qualified individual stating that you have a disability under the Fair Housing Act and how your request connects to that disability. But even then, I believe I know the community this is referring to, and it is a city ordinance that requires the association to do certain lawn care maintenance. If not applying the chemicals would bring the association out of compliance with the ordinance, I think the best thing to do would be to coordinate with the city on that reasonable accommodation request. You wouldn't necessarily want to unilaterally agree to violate this ordinance. You would want to involve the city in that discussion.
The next one is if trash cans have to be placed on the side of a home shielded from view, what reasonable accommodation can be met for someone claiming it's too difficult to walk in the grass with their disability and their fixed income prevents them from installing a sidewalk or pavers? So, this is one where, like Ashley was mentioning, you don't have to use magic words. So if someone were to come to you and say, listen, I've got, an injury or some condition where I can't walk or I'm unsteady on grass and I'd like to keep my trash can somewhere else, you've got to understand that what they're doing there is they're asking for an accommodation from a rule. And they don't have to use the words, I'm disabled and I'm asking for a reasonable accommodation. But if they present you with enough facts in their request, that's a request for a reasonable accommodation. You have to act accordingly on something like that. We think you probably are going to have to let them store their garbage cans in an area that might violate the rule, that might be in public view, despite the rule that says that they have to be out of public view.
I think the next one we got, the last pre-submitted question was, if a POA grants an accommodation, can the accommodation be conditioned on the removal of any exterior modification required as part of the accommodation upon the sale of the property? I pulled up, I wanted to directly quote the guidance on this. Okay, so the Department of Justice and HUD have issued this joint guidance that it's basically a 50 or so question Q&A. And this is essentially one of the questions, and their response is no. The Fair Housing Act provides that housing providers, which is a very nebulous term that in most cases includes POAs, may only require restoration of modifications made to the interior of a dwelling at the end of a tenancy. So reasonable modifications such as ramps to the front door of the dwelling or modifications made to other common areas are not required to be restored by the owner, or by the tenant. One of the problems we run into is that almost all fair housing guidance is written from the perspective of landlords and tenants. There's very little POA specific guidance. So sometimes we're left interpreting, okay, well, how do we think they would apply this guidance for landlords to an association? And in this case, I don't believe that associations can require the removal of an exterior modification when an owner moves out or otherwise vacates the property.
And we're going to go to the questions that have been submitted through Q&A. We have many people over age 65 that have asked for discounts or the removal of the finance charges due to age. I would think that this is discrimination to other owners based on age, but I'm now wondering as well if there is some sort of set of precedent that allows for this as an accommodation. So this really is not a accommodation under the Fair Housing Act. They just don't want to pay it. and they may legitimately not be able to pay it, but they don't, there's no protection for this type of request.
Yeah,
So that's
and
when
age alone is not a disability. So,
yeah, so this is something
yeah.
you just try to work it out with them. You know, and typically if they're paying a finance charge, it means that they didn't pay on time. So I would encourage them to get on a payment plan before finance charges start hitting.
Once an HOA has allowed the accommodation, and if the resident dies, can we ask for the accommodation to be removed? Do we have to have that stated up front when first presented with the accommodation request? I think this would fall under the same guidance. You typically can't require removal of a modification to the exterior of a dwelling. There's very little guidance on whether you can require a subsequent owner to remove something that was installed for the as a modification for the prior owner. But I think the safest approach is to say the modification gets to stay. What if the request? Sorry, go ahead.
What if the request is for a homeowner's guest and not specifically the owner? The Fair Housing Act protects the people who live in the home.
There's
Ashley, do you know anything different than that?
Yeah, so the definition of, well, not the definition of a disabled individual, but there's a portion of the Fair Housing Act where they're discussing disability discrimination more generally. And it does say that it prohibits discrimination based on the disability of an owner or a resident or somebody associated with that owner or resident, which is very broad. It hasn't really been discussed in the context of accommodations. I think some things might depend. How often is that person over? What's the connection to the owner? But I mean, it's going to be a very fact-specific inquiry. So you probably will want to talk with an attorney in more detail on that, but it's possible. Like I've dealt with one before where the request was made on behalf of an owner's niece, but she was at their home like 3 times a week and they watched her while her parents were out and things like that. So that was a little different.
So I think that the takeaway is that you've got to be careful with these, and you really, the first step is learning how to recognize a request that may involve a request for an accommodation.
Mm-hmm.
So you just got to be able to recognize those. And like Ashley said, if you've got any question at all, talk to your attorney to see if there's anything out there. Because sometimes it's surprising, what the law covers. It's, a group home can be for recovering alcoholics and they're protected. Now, if it's recovering drug users, if they're currently taking drugs, they're not protected. But if they're recovering, they're protected. And a group of recovering drug addicts can move into a single family neighborhood and, they can have 5 or 6 of them in the house, and that's not a violation. So you've got to be careful, be able to recognize when you might need to talk to your attorney about when something may or may not be protected, or when someone is or is not requesting an accommodation.
Yeah, it is an incredibly fact-specific discussion when you're deciding whether or not something has to be granted. So it is always a good idea to involve somebody who's familiar with the guidance and can kind of walk you through that process. If a request is made to modify the exterior common elements, such as a ramp instead of stairs, is the HOA condo expense or at the expense of the homeowners? Modifications to common areas, the associated costs are assigned to the homeowner by the Fair Housing Act and applicable guidance. So if somebody wants to modify a ramp, or sorry, stairs into a ramp, the association's role would be to allow that modification, but the requesting party would be responsible for the cost of actually affecting it.
So, a lot of clubhouses are old and probably might be inaccessible to for example, someone with a wheelchair. There's no requirement that you make them all handicap accessible, but if you go to remodel your clubhouse, the applicable building codes are probably going to require that you make it accessible at that time.
Mm-hmm. And I think the cutoff for that might be There's a portion of the Fair Housing Act that deals with building codes for accessibility. And I believe the cutoff is if the certificate of occupancy was issued after, I want to say 1997, but sometime in the 90s. So that is something to think about. If you're a newer association, then your contractor or the developer should have, typically they take the steps to make sure that they're complying with building codes. So hopefully that's not an issue.
So there's a question of what should a single family HOA do if an owner requests the common areas be made more ADA accessible, but is not specific. I mean, I think you can follow that up and ask them, what is the issue they're having? See what that response is, and then determine if it's something that either legally has to be done or something that maybe the association should do.
Yeah. And you'll get a lot of owners who throw around references to the ADA or the Americans with Disabilities Act. Most associations are not subject to the ADA. It's possible if you have amenities that are open to the public, but for the most part, you only need to evaluate under the Fair Housing Act because the ADA probably does not apply to your association.
And I think that's an important distinction. Actually, if your common area is open to the public, there's probably going to be some other requirements that you have to meet if you're allowing members of the general public to come in, and you may have to make your facility completely handicap accessible.
Yeah. The CFR for fair housing, some chapters are reserved. How can you review those chapters? I think when it refers to a reserved chapter, there's not, I'd have to go back and look, but typically chapters that are reserved, there isn't actually any text. They're just saving it. So they have basically a placeholders for if they amend in the future and want to add subsections, they're not having to, like the numbering will make sense. So typically reserved chapters don't, you don't really need to worry about those. The owner failed to request pre-approval prior to making a reasonable modification. Can the association still dismantle the reasonable accommodation, even though the association did not provide the hearing and ignored the email we sent advising really? That sounds like a pretty specific question. It's kind of difficult for us to answer anything that's, we can answer more general questions on here, but it's hard to get into the specifics of a question.
I mean, generally I would say that just because somebody perform some kind of modification without getting approval, that doesn't mean that the association is going to have the right to make it go away. So that, if you pursue that as a violation and then they respond and say, well, we did it because of, this person is in a wheelchair and we needed this, then you're really in the same place as if they had asked beforehand.
The next part of that question is more of an administrative question about how an investigation is handled. If the Fair Housing Authority, I think is what you're referring to, failed to do an investigation as HUD stipulates. I don't know the internal requirements for what an agency is required to do as part of their investigation beyond reviewing the complaint and any sort of response. I don't think there's anything that requires them to do much more than that.
Probably need more information about that question.
Yeah.
So, see, there's one above that. I think we may have missed it.
Oh, sorry.
Does the FHA apply to all POAs? Part of our community borders a public street and part borders private streets. Our community is in two parts, building plots and common area with a clubhouse. Well, the short answer is yes, the FHA applies to all POAs. I'm not sure what the distinction is between public streets and private streets, but if it applies to all POAs. Most clubhouses are on private property, i.e. property owned by the association. And if someone makes a request in which the law requires that an accommodation be given, then the law is going to apply.
What about someone asking to convert? I think that's supposed to say garage or add an addition to their home for an elderly family member that is either moving in or can no longer climb the stairs. To the extent that the homeowner is, or that the disabled family member is moving in, you may have to grant that request. that's going to be another really fact specific one, but typically, to the extent that they have a room for somebody, but they can't access that room because they can't climb the stairs, that may require the association to allow an addition. Any sort of additions still have to comply with applicable building codes. So that's something to consider. But possibly, I hate to give the attorney answer if it depends, but it depends. What happens when the agency issues a no cause determination, and what happens when they issue a cause determination? Do they need to issue the response in 100 days? Most agencies shoot to have an investigation and completed and a decision rendered within 100 days of the complaint being filed, but I will tell you from experience that almost never happens. So they typically will send something out shortly before that window ends saying, we're not going to reach a determination in the first 100 days. And then it might be over a year. I've seen 2 or 3 years. If a no cause determination is issued, the association doesn't really have to do anything. The owner potentially has the ability to file a lawsuit. And same thing with the cause determination. If a cause determination is issued, a lawsuit might be filed on the owner's behalf by a state agency or the Department of Justice, or they might say, we think that there was discriminatory housing practice, but we don't necessarily think it's the best use of our resources to file a lawsuit. You can file one on your own behalf if you want to. So there's not really an automatic step that happens next. Best place for fair housing training. I think it's always a good idea to reach out to the agency in your city that handles requests, because they can either do it a lot of the time or put you in contact with somebody who can. Our firm and a lot of other law firms will offer fair housing training for boards. So that is, you do have a few different options.
And I think you can Google a lot of information. I would look for information that's coming from a governmental agency. It's probably the best place to do research, and not necessarily rely on information you might see that's not from a governmental agency. I think the federal government, and I believe that the state government also has information online about fair housing issues.
Yep.
Let's see the next one. If you recommend an alternative modification, does that open you up to liability? Actually, what's your experience with that? If you have a dialogue where they want something, you say, well, what about this?
Yeah, it depends on how that discussion goes. Typically, if there are 2 potential solutions, and it's not a situation where one of them meets that qualification of fundamentally altering the POA's services or anything like that, it's typically up to the homeowner with a disability to choose between the 2, to say, my needs are this. I think that this option will better serve my needs. So you can find your hands tied. One option that you have if a complaint is filed is to engage in something called conciliation, which is it's really just mediation that's mediated by typically the investigator that's handling the complaint. And that can be a good way to hash out. I mean, obviously you don't want to invite somebody to file a complaint, but if a complaint has been filed, that's a good opportunity to sort of hash out potential options without worrying about, oh, am I saying the wrong thing? Because it's almost a safe space where the investigator will kind of mediate those discussions. But if the complaint has not been filed and you have 2 potential modifications, the guidance seems to suggest that you should go with the one the homeowner chooses.
Next one is, I have a board who wants to reduce section-specific assessments in a particular section, as they are under an assumption that many owners in this section are older and are fixed incomes. This has left one section with overall, I'm assuming, assessment rates that remained unchanged from 2021, while all other sections in the association have had their dues increased. You've got to be careful here. I think you've got to look at your governing documents. A lot of governing documents say that the assessment rate has to be uniform on all lots. So I think unless there is some very specific language in the governing documents that gives the board the authority to charge one section one rate and another section another rate, you've got to really be careful. It really just is fact specific to the governing documents of whatever this association is. And as most of you may know, what appears that they're talking about here is there's an association that has various subdivisions under its jurisdiction, and each section probably has a separate set of restrictions. So really, you've got to look at the governing documents, but I would be very careful about having some sections on one rate and others on another rate. And you really need to make sure you've got the authority and the documents to do something like that.
If there are no steps between a driveway and a garage, would the POA have to address sidewalks in the front? Okay, so I guess there could be two different situations here, sort of a townhome situation where maybe the area in front is a common area, or it could be a single family situation where that's the part of the lot that the owner owns. In either case, I guess it does matter. The distinction matters because if it's a single family lot, that probably takes the form of a reasonable accommodation where you're maybe waiving a rule that would otherwise not allow a sidewalk to be built. In which case that would be assessed under all the criteria we've discussed today. If it's property that's owned either by the association or by the owners in common, in the case of like a condominium, then as long as it doesn't violate any sort of applicable building code, you don't really, or ordinance, you don't really need to address it until somebody requests maybe a modification, in which case you might have to allow it, but you would not be responsible for the costs. As the association, the homeowner would be responsible for those expenses.
Does a homeowner have to request approval to operate a halfway house within the association? So I think this is something that I kind of mentioned before, and I use the term group home. So when I say group home, it generally means a home where there is a number of people living who are handicapped, which those people are protected by the Fair Housing Act, and a group home operator does not have to ask permission to operate a group home. So when you see something like that happening, the first thing you need to do is try to figure out what exactly is going on there. Sometimes it's obvious because the people are visibly handicapped. Sometimes it's not so obvious because there's no visible handicap, but that doesn't necessarily mean that they're not handicapped. So that's when you have to be careful about how you ask for information, which your attorney should hopefully be able to guide you in, is telling you this is how you need to ask of what's happening there, so you can try to make a determination. But the general answer is no. No one has to ask permission, but the law doesn't protect every group living arrangement. Like I said, and this is a kind of an example at the border, if 6 single drug addicts move in a house, that's not a group home. They're not protected.
Yeah.
So it's really just depends on the situation. And if you're talking about a halfway house of people that have been released from jail and have to spend some time in a halfway house, I don't think those people fall into the protection of the Fair Housing Act, unless they are otherwise handicapped in some manner. So it looks like somebody has presented a link to some fair housing training in Texas. I think Lindsay, who's our IT person, is on this call, I believe, and we can take a look and just confirm what that is. And if it is something useful, we can email it to everybody who's registered. So we'll try to do that too. I think that's the last question. Unless anybody else has got a quick one they can think of. Again, when you see a situation, the most important thing that I think we're trying to get across is that you have to be aware when you get a request, if it's triggering a request for an accommodation of the Fair Housing Act, and if it is, to make sure that before you charge off and write a violation letter on something you see, or before you respond to a request you get, you might want to talk to your attorney about it to make sure that you don't violate the Fair Housing Act. You don't want any lawyers from the Department of Justice coming down and poking around in your business, because they don't mess around when they do. And there's, like, Ash and I indicated, there's some state agencies that also have some authority here. So you just got to be really careful when you're in this situation. I think if that's it, I thank everybody for coming.
All right, thanks everyone.
See y'all later.